Boa tarde, doutor Bernardo, tudo bem?
Olá, boa tarde.
Boa tarde a todos. Me chamo José Manuel Fonseca Martinez, eu sou um dos diretores do Instituto Brasileiro de Multicorte, tá? E hoje eu vou estar aqui como gestor da rodada. Os juízes que vão avaliar essa rodada são a doutora Monique e o doutor Bernardo, tá certo? Nós teremos um embate entre as equipes 2644 e 2612. Eu vou confirmar aqui os tempos de cada uma das equipes, tá certo? Com o tempo que cada orador vai falar. A equipe 2612, que é a respondent, nós teremos Gabriela Belotti de Moraes falando por 15 minutos e Caroline de Caldas Bezerra falando por 15 minutos. E a equipe 2612, teremos Júlia Chaves de Guzmão falando por 12 minutos e Marcela Maria falando por 13 minutos. Os tempos são corretos?
Sim.
Alguém tem alguma dúvida sobre a condução das rodadas? Alguém quer tirar alguma dúvida, fazer alguma pergunta? Lembro a todos que, a partir do momento em que se inicie a fala da primeira equipe, a rodada vai ser conduzida toda em inglês, salvo as intervenções do Bailiff, as minhas intervenções. Essas, por sua vez, serão feitas em português, ok? Eu vou estar aqui controlando o tempo e vou enviar pelo chat por 3 vezes durante a apresentação de cada um o tempo que está faltando para a fala de vocês, tá certo? Bom, então vamos lá. Deixa eu só pegar aqui o meu controle para a gente poder começar. Ok. Vamos lá. Um instantinho. Vamos lá. Prontinho. A equipe que está representando o applicant, que é a 2612. Quando vocês estiverem prontas para iniciar a apresentação, eu peço que vocês me comuniquem para que eu possa iniciar a contagem do tempo.
Eu já estou pronta.
Está pronta? Nós iniciaremos pela Júlia?
Exato.
Pela Júlia, né? Então, Júlia, você tem o tempo de 12 minutos, tá certo? Eu vou fazer a comunicação quando faltarem 10, 5, 3 e 1. Ok? Então, sinta-se à vontade para dar início. Então, logo você diga a primeira palavra, eu inicio a contagem do tempo.
Okay. Greetings, Mr. President, Vice President, and members of the court. My name is Julia Guzmão. Me and my co-agent are here for the presentation of the Federal States of Anhur, and I will be using the time of 12 minutes. We will also reserve 5 minutes for the rebuttal, and my presentation will consist in 3 major arguments. First, Anhur's military response is covered by international humanitarian law. Second, the military camp was lawfully targeted and the precautionary measures were taken by the applicant. And third, Anhur is sheltered by the principle of military necessity and it is not liable under international environmental law. Subsequently, my co-agent will enumerate and present her points. First, with regard to Anhur's actions on the Manhattan complex, the applicable law must be observed. The case refers to a non-international armed conflict as defined in a common Article 3 to the Geneva Conventions. Since the use of force by Anhur was only directed towards an armed group, the conflict that extended to the territory of Rongo remains under the aegis of the law applicable to non-international conflict. And there is no treaty norm that explicitly addresses environmental damages during non-international conflicts. Most legal provisions of war protecting the environment were designed for international conflicts and not spontaneously applying to non-international ones. Hence, ANHR is only bound to norms of treaties of which it is a signatory, such as the Geneva Conventions, as well as those that assume the status of customary law to non-international conflicts. Hence, the customary law of non-international conflicts provides few restrictions. The norms that are considered to have customary status are, for instance, the general principles of humanitarian law, such as those of distinction, proportionality, and military necessity, all of which were duly met, as I will explain now on my second argument. Having that in mind, I now proceed to my second pledge, which is that the military camp was lawfully targeted and the precautionary measures were taken by the applicant. Despite being a Ramsar site, the man-made wetland complex is not unconditionally protected from any attack, especially if it shelters a military objective. Thus, the camp located in the wetland complex was lawfully targeted. And according to Rule 43, paragraph 1, yes,
I have a question. Even if we don't consider that both parties are parties to any of the agreements or conventions here, I believe that the protection to the environment in armed conflict, no-international armed conflict, whatever, can be considered customary international law, right? I'd like you to talk more about this, even disregarding all the conventions. Can this be considered customary international law, and thus both parties have to comply with?
Considering the circumstances of an armed conflict, we believe that the applicable law must be the customary law that relates to humanitarian law. Such the general principles and some of the ICRC rules and studies.
Does this International Court of Justice have any case law regarding the protection of environment in cases of armed conflicts?
Yes. For instance, just a minute. In the case, for example, the ICJ recognized the rule of distinction in the nuclear weapons advisory opinion, and also, I cannot remember the exactly case right now, but I surely can deliver that information in the rebuttal. And shall I proceed? Okay, as I was saying, the camp located in the wetland was lawfully targeted, and according to Rule 43, paragraph 1 of the customary humanitarian rule defined by the Committee of the Red Cross, the environment shall only be protected against any attack if they do not contain a military objective. And its Rule 8 also defines the customary concept of military objects as those which by their nature, location, purpose, use, make an effective contribution to military action and whose neutralization offers a definite military advantage. And in this way, the man-made wetland complex was a definite military objective, as this was the place from where armed drones were launched to kill several civilians in ANHR, making it an evident shelter spot for the rebels using the area clearly for military purposes. And after the damage suffered by ANHR, it was recognized that a successful operation against the military camp set in the man-made wetland complex would significantly scale down the presence of armed rebels and shorten the path to peace, which in fact did. And this further highlights the precautionary measures taken by the applicant when designing its military operation. Besides the understanding that no civilians live nearby, ANHR also used drones to limit the strike to the camp and secure the success of that singular attempt in weakening the threat to its civilians. And when it comes to the compliance with the rule of distinction, ANHR duly respected this fundamental principle, which allows attacks when the target is a military object. The use of the area as a military camp turned it into a military object. And the operation also occurred in full compliance with the principle of proportionality, as the target is sufficiently important. And it is proven by the outweighing interest of the measure taken by NHER, since the foreseeable damage of a precise attack against a singular and uninhabited area would be of much lesser relevance when compared to the further losses of innocent lives. This is not unknown to the international case law established by the International Tribunal for Yugoslavia in the NATO bombing case, specifically in paragraph 19, which determined that if the target is sufficiently important, a greater degree of risk to the environment must be justified. And thus, even in wartime—
Why are you considering this area of non-civilian character? Just because there are no civilians living there? What's your basis to consider this a non-civilian area? Because it's not a military basis, right? For you to argue this. So what's the reason for it to be non-civilian?
We rely that it is non-civilian because it has turned into a military object since a military camp was set by the ANPFF armed group. And thus, even in wartime, a certain level of environmental damage is allowed. This is actually proven by the very existence of rules which prohibit greater levels of damage. For instance, the prohibition of widespread, long-term, and severe damage to the natural environment foreseen by the Additional Protocol 1 for the Geneva Conventions, to which the applicant is not even a signatory. It places a specific limit in the kind of environmental destruction that can be tolerated. And this fact alone presupposes that even the most protective agreements will accept a certain amount of harm to the environment. And even more, this rule exhibits vagueness and inconsistency without an international consensus in its application, as the concepts of widespread, long-term, and severe remain without an agreed definition. And these imprecise concepts must be cumulatively identified in order to be considered prohibited. And furthermore, this rule specifically prohibits methods or means of warfare that are intended or may be expected to cause this type of damage. And this means that those rules prohibit the state from launching an attack, knowing exactly its risks. And having presented these allegations, I now turn the focus to a third claim, which is that NHER is sheltered by the principle of military necessity and is not liable under international environmental law. Concerning military necessity, this rule has been established as a norm of customary international law applicable to all types of armed conflict. And it was emblematically used in the hostages trial at the Nuremberg Tribunal as enough to justify environmental damage. And in this case, a concept called the Rendulic rule emerged, according to which situations have to be judged as they appear to the military actors at the time. And this means that the subjective perspective of the commander at the time of the operation occurs is what defines the military necessity, and that perspective was endorsed by the ICTY in the NATO bombing case. And your honors, according to the ICJ, environmental conventions could have intended to deprive a state, could have not intended to deprive a state of the exercise of its right to defend itself, as stated in the advisory opinion on the nuclear weapons, most specifically in the paragraph 30.
You mentioned precedents of the ICTY and precedents of the Nuremberg Tribunal. Why are you mentioning this? Do we in the ICJ have to follow these precedents? It's not even from the same court, so what's the relevance?
Some ad hoc criminal tribunals established by the United Nations are known to establish very relevant contribution to international humanitarian law by affirming the customary nature of certain rules. And for instance, this court has already used interpretations by the ICTY in the case concerning genocide in 2007. Can I proceed? And the normal applicability would further depend on the relevance of the military interest compared to the environmental interest and who would likely be affected. And in this sense, the military objective of stopping the continuation of attacks against unruly civilians proved to be more relevant than ensuring the protection of an uninhabited area, which means that NHR's duty to protect civilians outweighs the harms to Rongo's interest, and that situation prevents the application of international environmental law. And according to the ICRC, the only rule that directly protects this environment, which is customary to non-international conflicts, is Rule 43, which reads in its paragraph 2 that the destruction of any part of the natural environment is prohibited unless required by imperative military necessity. That said, the context of military necessity makes NHR not liable under international environmental law, given the need to protect its population. And the unavoidable military measures taken by NHR comply with the rules of international law. As such, not to recognize the applicant's military necessity would be to legitimize the aggravation of the killing of NHR citizens, likewise the destructions of NHR civilian patrimony. I now finish my pledge and I pass the floor to my co-agent.
Agora, ainda representando o applicant, a oradora Marcela Maria vai falar pelo tempo de 13 minutos. Quando quiser, Marcela.
Good afternoon, your honorable judges. May I please the court? I am Marcela Naum, and I will now defend the second and third segments of arguments presented by the federal states of NHR, which are: first, the damage caused to the Mahent wetland complex is not considered a wrongful act, and its consequences are not fully attributable to NHR. And second, Rongo's hotel project in the Escuto coastal wetland breaches international law. If I may, recalling what my colleague already established, the military response adopted by NHR were excused by the insecurity and the danger that the armed group represented to NHR. Nevertheless, the respondent alleges that NHR did not follow its international obligations when addressing its target. This does not deserve to prosper, since NHR had a military necessity, excluding the wrongful character in question. Moreover, the causal link between the attack and the damage has been broken because of the respondent's negligence. Since 2014, it has been failing its duty towards the Ramsar Convention, letting the Mahent wetland complex suffer from an extended drought, which changed the ecological character in the region. Since Rongo did not follow the duty, it has to communicate the serious change to the Ramsar Secretariat, and who could not have expected that the operation would spark a fire with those dimensions, and was careful to use precise and non-incendiary weapons, but the fire was only ignited because of the drought condition, which could not be accounted for by the NHR military, since they could have not known about it. Thus, the causal link of the collateral damage has been broken, which affects any compensation pledge. Compensation deriving from environmental damage has been recognized by this court on Costa Rica and Nicaragua. However, in that case, this court expressed that in order for compensation to be granted, a causal link between the damage and the wrongful act by the state must be presented. In our case, one cannot find such a causal link on the proportionality of the attack and on the damage incidentally caused by unexpected fire. Rongo's lack of will in preserving the area and at least fulfilling its duty of publishing information was the reason for the incidental fire and the final damage, therefore breaking the causal link between NHR's actions and the resulting damage. More recently, in the judgment of February 2022 of the case Armed Activities on the Territory of Congo between Congo and Uganda, reinforced that compensation can be awarded only if there is a sufficiently direct and certain causal nexus. Thus, the compensation pledged by the respondent may only be disregarded. As my second argument, I shall discuss that the Rongo's hotel project breaches international law. And more specific, I shall present that first, the obligations under the Ramsar Convention are applicable since the Escuto coastal wetland is still a Ramsar site. Second, even if the wetland is not considered a Ramsar site, Rongo is still signatory of Ramsar Convention and recognizes the general duty to preserve wetlands. And third, Rongo is bound to the duties under Article 3.1 of Ramsar Convention and the wise use of wetlands. So primarily, we sustain that since the Escuta coastal wetland is still a Ramsar site and the obligations of the Ramsar Convention are applicable, despite the existence of the draft articles on state succession, the Article 12 of this document is the only one which was recognized by this court to be customary international law in the Gabikovo-Nagmaros case, when it was confirmed that succession of states does not affect obligations relating to the use of any territory or to restrict upon its use established by the treaty for the benefit of a group of states or for all states and considered as attaching to that territory. The Ramsar Convention is a treaty that fits this definition and imposes obligations and limits on the use of a territory with the purpose of preservation, namely the wetlands. Hence, Hong goes against international law for using sovereignty allegations over Camp Keys in order to neglect obligations of protecting the wetland. And even if the Escuta coastal wetland was not considered a Ramsar site, Rongos is still a signatory of the Ramsar Convention and recognizes the general duty to preserve wetlands. In its Article 3.1, the Convention calls upon parties to formulate and implement conservation measures for all wetlands, listed or not as Ramsar sites within the territory of the signatory parties. And in Article 4.1, it states that contracting parties should promote the conservation of wetlands, even establishing natural reserves. In this sense, even the remote possibility of being recognized that the Escuta coastal should no longer be considered a Ramsar site, Rongos is still a signatory to the Ramsar Convention and has, therefore, accepted its provisions beyond the wetlands it has listed. In this sense, Rongos is bound to the duties under Article 3.1 of Ramsar Convention and the wise use of wetlands, which equates to the obligation to institute a no-loss approach policy. Since 1971, this convention has the avoidance of wetland losses as its overall objective, by exemplifying two main ways of achieving this goal. First, by the selection of a non-damage location for a development project, and two, by opting for a no project option when the damage is assessed as being too high. Resolution 11.9 reaffirms such.
Agent,
Yes,
you
Honor.
and your co-agent mentioned the concept of necessity. But I'd like you to explain what's necessity in international law, what's the definition, and if you could bring up a case of the ICJ that discusses a case of necessity of one of the parties.
Yes, Your Honor, and thank you for your question. In our case, the military necessity corresponds to the imminent danger this group, the armed group, represented to end society. And when we talk about military necessity, we must understand that when a state acts in the military, according to military necessity, it has to be assessed that the measure will represent a military advantage. So in our case, the military necessity was used as a response to the danger that this group represented to Enher. Before a previous case that the military necessity has been used was in the NATO bombing case. So may I proceed? Okay, thank you. So since 1971, the Ramsar Convention has the avoidance of wetland losses as its overall objective by exemplifying two main ways of achieving achieving the goal of protecting wetland losses. First, by the selection of a non-damage location, and two, by a no project in case the damage is assessed as being too high. So as I mentioned before, the resolution 11.9 reaffirms such commitment in its Article 14, when it was agreed that avoiding negative impacts should be the primary step in strategies for stemming the loss of wetlands. The respondent, however, chooses not to comply with such obligations and breaches international law when selecting a protected area and a nesting habitat to construct the massive project. In light of the scale of preference that should be applied in accordance with Resolution 11.9, there is no justification for this choice at the risk of damage is clearly too high, and a different location for a non-project or a non-project option would be perfectly feasible. Even if the choice is not to avoid wetland loss, wise use dictates that mitigation and compensation measures must be taken. It is true that the EIA conducted by Rongo recommended the placement of some mitigation measures to avoid the lights reaching the nest habitat of the royal ridley, but no compensation measures for wetland deforestation are foreseen. Here, it is important to stress that while such compensation may be accepted, the overriding and primary duty is to avoid the need for such compensation in the first place. So also,
how would you, in case we establish that the compensation must be paid, how do we establish a value of this compensation? Do you know of any precedents of the ICJ? Does this have to follow national law? How do you deal with that?
Thank you, Honor. Actually, the compensation term that I had used in this sentence is the same compensation and has the same meaning as the Ramsar compensation foreseen in Article 4.2 in compensation measures. But ICJ has recognized compensation for environmental damage between states, sovereign states, in several cases, as I mentioned when I was talking about the compensation pledged by the respondent, as the Uganda and Congo case, certain activities carried out by Nicaragua between Costa Rica and Nicaragua, and in the case between Congo and in a different case where Congo was the respondent. May I proceed? Also, Rongo disrespects the protection provided by international law to the royal ridleys as a duty not to cause transboundary harm. The royal ridleys is a critically endangered species. It has its worst largest nesting in the Scuto coastal, with approximately 35% of the nests from its global population being located there. Resolution 13 of 20.24 of the Ramsar Convention states that the places that are threatened by human activities, such as tourism development, should be keeping away the human activities. Also, in the Inter-American Convention for the Protection and Conservation of Sea Turtles, specifically Article 4.c of the Convention restricts human activities that could seriously affect these animals. Moreover, the Convention on Biological Diversity in Article 8 also requires parties to develop protected area in places important for the perpetuation of biodiversity. This is also reinforced in Article 14.c and 14.d of the same convention, when the convention goes even further, when it states that in the case of imminent or grave danger or damage that it may cause damage in another state, the state that oranges the damage has to notify immediately the potentially affected state of such danger or damage. For all exposed, Rome clearly violates several provisions of international law by building a massive hotel immediately adjacent to the nesting habitat. In this matter, we must discuss an analysis of transboundary harm. The duty of do not cause transboundary harm is a customary international law that has its roots in the trials matter arbitration. It was reaffirmed many times by international tribunal, including by this court. In paragraph 104 of certain activities carried out by Nicaragua, it was stated that if there is a risk of transboundary harm, the state planning to undertake the activity is required, in the conformity with its due diligence obligation, to notify and consult with good faith with the potentially affected state, where that is necessary to determine and appropriate measures to prevent and mitigate the risk. This is also in accordance with draft articles on prevention of transboundary harm in its Article 3, 4, 8, and 9, and Article 5 on Convention on Biological Diversity. The royal ridleys that hatch in Camp Key also spend part of their life cycle in Henry's territorial waters and are important species for the region's ecosystem. Contrary to this, Rome conducted an ELA all by itself, and its unilateral action surely does not comply with the obligations aforementioned, including the due diligence to institute all the procedures required to ensure that the duty not to cause transboundary harm will not be breached. Finally, as my fourth and last argument, I will prove that the wrongles. I thank you, Your Honors, for the time, and I pass the floor.
Perfeito, parabéns à primeira equipe pela sustentação. Para fins de transparência, foram utilizados 25 dos 30 minutos atribuídos à equipe, então a equipe ainda terá o período de 5 minutos para se manifestar na réplica. Partimos agora para a sustentação oral da segunda equipe, a equipe de número 2644. Iniciaremos pela oradora Gabriela Bellotti, que falará pelo tempo de 15 minutos. Gabriela, quando quiser, sinta-se à vontade. Assim que você iniciar a fala, eu iniciarei a contagem do tempo.
Good afternoon, Your Excellencies. Is everyone hearing me well? Perfect. May it please the Honorable Court, my name is Gabriela Bellotti, and also on the panel is my co-agent Caroline de Caldas Bezerra. We appeal on behalf of the respondent in the present matter, the Republic of Rongo. I will address this court for 15 minutes on the question of whether Rongo violated international environmental law with respect to the hotel complex project, as well as why UNHWR violated Rongo's sovereignty with its armed attack on the Manhit wetland complex. My co-agent will be furthering my submissions by addressing the question presented before the court regarding the violation of international environmental and humanitarian law by UNHWR's attack on the Manhit wetland. My speech will specifically address that first, Rongo did not violate the Inter-American Sea Turtle Convention nor the Convention on Biological Diversity. Second, that Rongo complied with the principle of sustainable development. And finally, that UNHWR violated Rongo's sovereignty. Your Excellencies, to contextualize my submissions, if we may look at page 12 of the record, the Rongoan Ministry of Environment and Sustainable Development announced that it was granting a permit for the construction of a hotel complex within the skewed coastal wetland in Kemki, with the objective of increasing ecotourism in the area, as well as promoting the development of the local community. Now, we highlight that an environmental impact assessment was indeed conducted prior to the announcement, and observations were made in the permit as to only allow the constructions if measures were taken to block internal lights that may interfere with the royal ridley's nesting habitat. That said, Your Excellencies, the project perfectly complies with the Inter-American Convention for the Protection and Conservation of Sea Turtles. This convention has never prohibited human activities in the nesting areas of animals, but rather instituted that measures must be taken around those areas to protect, conserve, and recover the sea turtle population and their habitats. Now, further, in the AAC Annex 2, Item 2, parties should adopt measures to protect and conserve sea turtle habitats within its territory and managing, of course, when necessary, the use of artificial lighting. Now, in parallel, we like to highlight resolution number 11.9 from the Ramsar Conventions, which proposes a framework and guidelines for avoiding, mitigating, and compensating for wetland losses. And this includes changes to the scale, design, location, management, or monitoring of the proposed activity, as well as restoration and or rehabilitation of sites. Now, more specifically, as listed by the Sea Turtle Conservancy, one of the biggest institutions in sea turtle protection in the world, mitigation measures could either be the use of special fixtures to shield lights from the beach and tinted windows facing the beach. Now, as mentioned, Your Excellencies, by conducting this EIA, Rongo managed to anticipate the potential harm that artificial lighting could cause and adapted the permit, therefore complying with CBD's Article 14 that provides guidelines for impact assessment and minimizing adverse impacts, notably adopting procedures requiring environmental impact assessment of projects that are likely to have significant adverse effects on biological diversity, and also introduce appropriate arrangements to ensure that the environmental consequences of said projects are deeply considered. That said, Your Excellencies, Rongo's actions were appropriately taken not only to achieve the purpose of the AAC to protect the turtles, but actually complied with CBD guidelines on impact assessment. Now, for my second submission, Yes.
You're talking about the mitigation measures that your state took to protect the turtles from the light pollution, but can you provide any evidence that these measures really conduct to the protection of the turtles? Because I see you saying that you conducted the environmental impact assessment and blah, 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 but what's the evidence you can bring to the court that this would really ensure the protection of these species?
Your Excellency, first off, we highlight that the skewed coastal wetland has been facing serious amount of exploitation and, in all seriousness, neglect from its previous sovereign country. However, with the added attention that this hotel complex would bring, it's already going to deeply enhance the protection of turtles over there. However, we also have the EIA according to our national legislation, that the lighting would be the only likely risk to the turtles, and we are already applying mitigation measures to that. And the fact that we are postponing the construction of the hotel after this matter is settled before this court only shows that if anything were to come up in the future, Rongo would be compromised with applying mitigation measures to that. Now, that said, the complex project also complies with the principle of sustainable development. In fact, with it in mind, the Rongoan Ministry of Environment Sustainable Development allowed the construction of a hotel as a way to increase ecotourism and help the impoverished local community. Now, for some context, Your Excellencies, it is known that the skewed coastal wetland faces inappropriate agricultural practices, subsistence hunting, overexploitation of marine resources, and other development pressures, as mentioned in the Ramsar listing in the paragraph 17 of the record. Now, that said, Article 11 of the CBD establishes that states shall adopt economically and socially sound measures that really act as incentives for the conservation and sustainable use of biological diversity. In parallel, we highlight that the IAC provides the states with the duty to take appropriate measures for, notably, the promotion of environmental education and also dissemination of information with the purpose of encouraging participation of not only government institutions, NGOs, and the general public, especially in those communities that are involved with sea turtle populations and their habitats, such as in the skewed coastal wetland. Now, Your Excellencies, those rules with environmental protection at the forefront allow member states to increase ecotourism, which, for context, is a form of tourism involving responsible travel to natural areas, conservation of the environment, and improvement of the well-being of the local people. Now, regarding the latter, the IAC establishes in its Article 2 that it is necessary to take into account socioeconomic characteristics of the state in discussion. And that is so that middle-income developing countries like Rongo have room for development, both economically and socially. This is, in fact, supported by the preamble of the CBD that recognizes that economic and social development, as well as poverty eradication, are the first and overriding priorities of developing countries. Consequently, Your Excellencies, the construction of...
Yes. How is the construction of a hotel complex helping impoverished people? Because I mean, it's gonna help to fill the pockets of the owner of the hotel and big companies. I can see how does this relate to the principle you're talking about, sustainable development. I mean, if you're so worried about protecting all these species and with the Ramsar Convention, you wouldn't even allow a company to build a hotel complex that big. So I don't really understand.
Your Excellencies, I understand the point and I understand the concern. However, as the Organization of American States document on tourism as an economic development tool states that the most important economic feature of activities related to tourism sector is the fact that they contribute to 3 high priority goals of developing countries. First, the generation of income to the people. Second, employment of those people, and also foreign exchange earnings in people from other countries visiting over there. Now, for some examples, in the Bahamas, tourism accounts for about 1/3 of the GDP, and most sectors of economic activity are directly or even indirectly related to it. Also in Barbados, which is also a Caribbean country such as Rongo, tourism is the leading economic sector, accounting for 15% of the GDP in 1992. In Jamaica, my final Caribbean country that I will be mentioning, the tourism contribution to the GDP was 13.4%, while in Mexico, it was only 4%. Now, that said, Your Excellencies, the construction of the hotel will bring both economic and social benefits, not only to Rongo as a middle-income developing nation, but mostly to the local community. Further, the project is strongly recommended by Ramsar Resolution number 11.7, as it makes wise use of the site and develops practices for sustainable tourism, poverty alleviation, local empowerment, and wetland conservation. To illustrate this, we highlight that in Brazil, there is a successful hotel project focused on ecotourism that has had a 17-year-long partnership with the Tamar Project, the largest Brazilian NGO specialized in the protection of sea turtles. And according to the Tamar Project, their partnership began with the construction of a hotel with advice regarding blight adaptation, which is the object of this matter, and extends to their current activities, mostly related towards public participation. Now, notably, over 100,000 guests were contemplated by such activities. This way, Your Excellencies, Rongo not only complied with Article 3.1 of the Ramsar Convention to make wise use of wetlands, but it is on the path to develop a successful green hotel that will ultimately only increase protection of the wetland by giving it the attention it actually deserves. Now, for my final submission, Your Excellencies, while Rongo fully complied with international law and principles, UNHCR clearly violated them by launching an armed attack on the Rongo's Manhit wetland complex, as my co-agent and I will soon demonstrate. For context on that, page 8 of the record states that on November 6, 2019, UNHCR fired approximately 200 high explosive artillery rounds at Rongo's Manhit wetland complex. UNHCR's artillery sparked a fire that burned 80,000 hectares of peat swamp in the area, approximately destroying 65% of the complex, resulting in the loss of trees, vegetation, soil, and wildlife. That said, the attack was carried out in utter disregard to Rongo's sovereignty. The United Nations establishes in its Article 2, Item 4, a prohibition on the use of force by member states. Moreover, we highlight that the wetland is a Ramsar site under the Ramsar Convention, which has the purpose to protect wetlands on a global scale, and particularly Ramsar sites, which are subject to enhanced protections. We also highlight that Article 2.3 of the Ramsar Convention ensures the maintenance of exclusive sovereign rights of the parties in whose territory the listed wetland is situated. Now, to illustrate, Your Excellencies, in certain activities in Nicaragua, the court recognized that Nicaragua violated Costa Rica's territorial sovereignty with occupation and use by its armies in Costa Rican territory. And it was later decided that Costa Rica was owed compensation. In fact, it was the first case for compensation for natural resources. Also, in the Democratic Republic of the Congo v. Uganda, the court rejected Uganda's claim of self-defense under Article 51 of the UN Charter. And this way, it held that Uganda had violated the sovereignty and territorial integrity of the DRC, as well as the unlawful military intervention by Uganda was of such magnitude that the court considers it to be a grave violation of the prohibition on the use of force. Therefore, Your Excellencies, we see diverse similarities between the cases of UNHCR and all those cases that we mentioned, and the attack on the Manhit wetland complex constitute a violation of state sovereignty, once UNHCR did not refrain from the use of force against Rongo, nor did it notify the state about its intentions, resulting in massive damage to the wetland. In that sense, we also like to highlight that the United Nations Environment Program document titled Protecting the Environment During Armed Conflict, an inventory and analysis of international law, states that the obligations imposed by Ramsar Convention can continue to apply during armed conflict. That said, Your Excellencies, Rongo sovereignty was only one of the many violations of international law by UNHCR, as my co-agent will now demonstrate. So unless the court has any further questions, that concludes my submission on behalf of the Republic of Rongo. I thank the court for its indulgence and may it please the honorable court. I will now pass the floor on to my co-agent.
Are your excellencies hearing me well?
Caroline, você está pronta? Se sim, vamos iniciar a contagem dos seus 15 minutos, tá certo? Somente para fins de transparência, a Gabriela utilizou 13 minutos e 50 segundos do tempo dela. Quando você estiver pronta, a gente pode iniciar aqui.
Okay, thank you. Mr. President, Your Excellencies, may it please the court. My name is Carolina de Caldas Bezerra, representing the respondent, Republic of Rongo. I will speak for 15 minutes regarding the following. First, UNRWA violated international humanitarian law as the Manhattan complex was not a legitimate military target. Second, UNRWA failed its duty to cooperate towards environmental protection. Third, and finally, UNRWA must compensate Rongo. Your Honors, my first submission will state the violation of international humanitarian law, since, at the case at hand, already exposed by my co-counselor, is consistent with its application. During armed conflicts, the international humanitarian law also seeks to conserve the natural environment, which is essential to human life. Additionally, the Manhi wetland complex did not characterize a military objective. According to International Committee of Red Cross, the environment is covered by general provisions regarding warfare. Unless this has been developed into a military objective, the environment is civilian in character and cannot be attacked, as it indicates in the principle of distinction to the natural environment, outlined by the guidelines on the protection of environment in times of armed conflict. In that sense, military targets are defined by Rule 8 of International Humanitarian Law as objects that by nature, location, purpose, or use make an effective contribution to military action and whose total or partial destruction, capture, or neutralization offers a definitive military advantage. Thus, as the Manhi wetland complex was not a military target, the environment should have been protected and clearly by no means attacked. Your Excellencies, it is very clear that by attacking the Manhi wetlands, UNRWA has violated international humanitarian law. The violations are twofold. Firstly, in regard to the lack of military legitimacy and proportionality to the attack, and secondly, in relation to UNRWA's duty as a member of the Ramsar Convention to protect all wetlands. In that sense, the ICJ has already expressed an opinion on the legality of the threat or use of nuclear weapons, and I quote, "States must take environmental considerations into account when assessing what is necessary and proportionate in the pursuit of the legitimate military objectives. Respect for the environment is one of the elements that go into assessing whether an action it is in conformity with the principles of necessity and proportionality." Your Honors, UNRWA's attack on the Manhi wetlands is neither a result of imperative military necessity, nor it is proportionate. It is an imperative, for it hasn't been sufficiently demonstrated by UNRWA that there was an urgent need for the said attack, or that there were no other feasible and satisfactory strategies. Strategies per se more proportionate and less harmful to the environment and to Rongo's territory. The information that a proportionality analysis wasn't conducted isn't enough to properly demonstrate that the means chosen for the attack were in fact proportionate, especially in facing the result that will take likely hundreds of years for the Manhi wetland area to properly rehabilitate itself. That being so, UNRWA's actions were conducted in complete disregard to the environment, as well as in dissonance of the duty of proportionality. In that sense, even if we consider UNRWA's proportionality analysis pointed to no excessive destruction, the fact that the said restriction wasn't foreseen does not absolve the warlike state of its duty to take effective precautions against environmental damages, which, as pointed before, was non-existent on our part. As such, UNRWA is also in discordance with Rule 44 of the ICRC Customary International Humanitarian Law Study. Above all that information, it is important to state that UNRWA's attack violates the UN Charter. Article 2.4 strictly prohibits the threat and use of force by its member states. However, states are exceptionally allowed to use force in order to defend themselves if they come under armed attack. Additionally, Article 51 allows the states to use force as a last resort to protect their integrity, but the right has a limit. Measures taken by the defending states. Yes, Your Honor?
You mentioned that according to the Article 51 of the UN Charter, it would be only a last resort. But can you consider that in the case of your state, the state used all the other possible resources, because the text you just mentioned explicitly mentions that would be the last resort. And I'm not sure if it was really last resort.
Yes, Your Honor, UNHUR did not take into considerations other strategies, because the attack was immediately, it was taken I think 1 month to UNHUR planned the back attack to the paramilitary group, and therefore UNHUR could have think and make another actions control to protect the UNHUR's integrity without violating Rongo's sovereignty. And moreover, once the Council has decided to act, the defending states must seize the measures taken in response to the armed attack. Therefore, UNHUR breached Article 51 from the Charter when acted without the Security Council's consent and attacked Rongo's territory. UNHUR actions also violated the duty to prevent transboundary harm. According to Article 3 from the CBD, states have the responsibility to ensure that activities within the jurisdiction or control do not cause damage to the environment of other states or of areas beyond the limits of national jurisdiction. This duty is also foreseen in the Ramsar Convention in its Article 4, the Stockholm Declaration, and the Rio Declaration principles. Now, this scenario...
ICJ precedents that deal with the issue of transboundary harm.
Yes, Your Honor. This scenario is very clear in numerous decisions by the ICJ, especially the pulp mills case, in which Argentina and Uruguay was discussing about the construction of 2 pulp mills in the Uruguay River. In this case, this river was a shared resource, and the construction of the pulp mills was would cause severe transboundary harm to Argentina's country. And it's one of the famous cases that discuss the transboundary harm issue. In the present case, UNHUR fired high explosively artillery rounds at the camp located in the Manhi wetland. UNHUR's artillery rounds sparkled a fire that burned hectares of the swamp in the Manhi wetland complex, resulting in great losses. These lands are known for being the house of numerous animals, besides supporting varieties of trees. Pursuant to the construction that arose from the fire caused in the Manhi wetland complex, the lack of recognition and accountability and consideration regarding the natural environment, it is clear that UNHUR violated the international duty to prevent transboundary harm. To start my second submission, I will further demonstrate that UNHUR also failed its duty to cooperate towards international environmental law, through both carrying out the attack itself and through the lack of prior notification or consultation. In failing to consider the damage its military attack would cause on the Manhi wetlands, UNHUR has breached the duty of cooperation among states in conserving the environment and biological diversity. A state's duty to cooperate in international environmental law is widely acknowledged through the presence of express provisions regarding cooperation in the preamble of Rio Declaration, as well in the Stockholm Declaration and the CBD. It is also evident, as in state practice, as is illustrated in the Mox Plan case, in which the International Tribunal for the Law of the Sea identified the duty to cooperate as a fundamental principle in the regime of pollute prevention. Further still, Principle 18 of the Rio Declaration declares that states shall notify one another of emergency situations that may produce harmful effects on another country's environment. UNHUR's military attack, as UNHUR claims, was an emergency situation, which by the aforementioned principle entails a duty to notify Rongo of the situation, since it had the potential to cause great environmental damages. Your Excellencies, I will finish my submission claiming to this honorable court to take into consideration all environmental harm UNHUR has caused to Rongo's population. With UNHUR's clearly violation of international environmental law and its link to the damage occurred in the Manhi wetland complex, Rongo gently requests compensation. By attacking the complex with no previous warning and caused mass destruction of the area, UNHUR's actions satisfy Article 2 of the Articles on Responsibility of States for Internationally Wrongful Acts, that lists the elements of internationally wrongful acts as a state, as well as Resolution 9.6 of the Ramsar Convention. Said resolution establishes compensation should be applied, not only for deletion or restriction, but also for a loss of ecological character due to development of other human-caused impacts. Following that, Article 31 of the Articles on Responsibility of States provides that states owe full reparation for the injury caused, whether material or moral. Regarding this subject, the ICJ has already decided on a similar matter. As in Nicaragua, the court ruled that Nicaragua was obligated to compensate Costa Rica for the material damages caused by its unlawful activities, calculating the value for restoration and the loss caused due to the damages. Therefore, Your Honors, UNHUR failed to fulfill its international responsibility towards Rongo. It must take action to repair the severe damage caused on the Manhi wetland complex due to UNHUR's military attack caused on 1919. Now, if the court does no longer need my assistance, I will conclude my submissions. Thank you.
Caroline, você encerrou a sua apresentação?
Yes, sim.
Ok. Você utilizou 10 minutos e 23 segundos do total de 15 minutos, somente para fins de transparência. Nesse momento, então, eu convido as representantes da primeira equipe para apresentarem a réplica. Vocês têm o tempo total de 5 minutos, ok? Quem vai iniciar vai ser a Júlia. Sinta-se à vontade, quando você iniciar, eu começo a contagem do tempo, ok?
Thanks. Does everybody hear me well? Okay. First and foremost, observing the fact that it was a military basis, the camp was, in fact, a military target, and the operation aimed only at it, complying with the rule of distinction. Second, Rule 44 of the ICRC is not applicable to non-international conflicts, according to the ICRC itself in a commentary of that rule. And third, the Ramsar Convention only mentions the duty of protection of wetlands by the state that shelters them in its Article 3. And fourth, the information that ANHR had a month to prepare its attack is nowhere to be found in the fact sheet. Actually, the facts state that both the attack and the response happened in a span of at least 6 days of the beginning of November. And fifth, the duty to give prior warning in war is only to warn civilians to leave the area, and ANHR has not breached this. Moreover, the duty of notification and consultation cannot be exacted against ANHR, as the element of surprise was essential to the operation. And for instance, the case law selected by the respondent, such as the pulp mills case and the construction of a road in Costa Rica, refers to circumstances relating to times of peace, and they are completely different from the concrete case. They cannot claim a violation of international law based on cases that do not even contemplate the most relevant and crucial element of the dispute, which is the very existence of an armed conflict. The respondent said that the artillery caused the massive fire. It is not true. It is a fact that the drop that is what led to the huge fire, and the mismanagement of the Ramsar site by the respondent was determinant for it. And moreover, ANHR's weapons were not incendiary, as in Protocol 3 of the Convention on Conventional Weapons confirms that incendiary weapons do not include explosive bombs in its Article 1.b. And concerning to the construction of the hotel, Rongo only determined the use of shade screens in one part of the hotel. The facts confirm that the permit would allow the use of spotlights in the hotel complex balconies, stairways, parking lots, restaurants, and the marina for safety purposes. Therefore, they didn't even follow its EIA in its entirety. And moreover, if Rongo wants to protect the skilled coastal wetland, why it is so determined to remove it from the Ramsar list, which enhances the protection? The hotel cannot be understood as sustainable tourism because sustainable use, because the definition of sustainable use means the use of biological diversity in a way that it does not lead to the long-term decline of it. As Judge Monique demonstrated her concern, it also impacts socially the community. The Ramsar Convention has recognized this before, and such a construction may lead to problems as high inflation and land speculation. And it was also alleged that Rongo did not violate Inter-American Sea Turtle Convention, but it supports this allegation in its Article 4.2, which states that parties shall establish necessary restrictions on the use of zones of turtles' habitat or nesting. Therefore, the federal state of Amherst reiterates all of its claims initially defended and hopes that this court, with its usual parsimony, will fully recognize them. Thank you, Your Excellencies.
Perfeito. Vocês encerraram a réplica, Júlia? Bom, então, nesse momento, tá, nós finalizamos a primeira rodada da competição da Stetson. Eu vou com os professores para uma sala privada para eles conversarem um pouquinho sobre as impressões da apresentação e deliberarem. Após eles deliberarem, a gente volta para a sala principal para que eles possam passar alguns feedbacks para vocês, tá certo? Lembro apenas que vocês continuam sendo transmitidos para o YouTube, então podem conversar, sintam-se à vontade, se conheçam um pouquinho, que é uma dinâmica bacana das competições, mas lembrem-se desse pequeno detalhe, tá certo? Eu vou abrir aqui a sala do breakout para levar os professores.
Oi, gente, tudo bem?
Olá!
E
Pessoal, parabéns, vocês foram muito bem.
Obrigada. Vocês foram muito bem também.
Vocês também arrasaram. Opa.
É só se eu falar com você. Vocês são de que universidade? Não sei se pode falar também.
não, pode não, pode não.
Não, depois eu pergunto se então.
Ai, meu Deus, eu já ia responder.
Eu acho que não pode não. Eu acho que isso foi até mencionado no memorial. Que a gente podia
entendi.
finalizar.
Então depois eu pergunto.
Bom, pessoal, estamos de volta. Os professores já deliberaram, conversaram um pouquinho sobre as impressões da rodada, que foram as melhores possíveis. E, portanto, encaminho aqui meus parabéns para as equipes. Foi realmente brilhante. Vocês demonstraram grande conhecimento e grande preparação. Não é fácil. É um caso complexo, com muitas nuances, e vocês conseguiram apresentar os argumentos com bastante desenvoltura e qualidade. Nesse momento, então, passo a palavra para o professor Bernardo, para a professora Monique, para que eles possam fazer os comentários deles acerca das apresentações das equipes, tá certo?
Bom, Monique, quer começar?
Se você quiser, pode começar. Para mim, não tem diferença.
Eu acho que eu vou ser mais breve, até porque acredito que as perguntas, como você colocou, teve a capacidade de avaliar o conteúdo, né? Eu fiquei muito atento à postura, à clareza e organização das ideias, e achei realmente vocês se prepararam muito bem, que vocês organizaram e conseguiram expor de forma muito clara. Eu entendi os argumentos dos dois lados e realmente dou os parabéns aí pela dedicação. Acho que ficou um trabalho de alto nível e parabéns, tá?
Eu anotei várias coisas, espera aí. Então, eu vou falar na ordem que elas foram falando, né? Acabou que a Júlia foi a primeira, mas ela foi a última também, né? Que ela fez o rebuttal. Assim, eu também achei que as 4 apresentações foram excelentes, assim, eu já vi várias rodadas de Stetson, desde 2007 eu tô vendo Stetson, que eu participei, depois eu fui juíza algumas vezes, e eu achei que essa foi uma das melhores que eu já vi, assim, eu achei muito difícil avaliar, porque eu queria que as duas tivessem a mesma nota e fossem para o final. E eu não vi as outras, mas eu achei, nossa, vocês foram muito, muito bem, assim. No geral, eu gostei muito que todas trouxeram casos e muita legislação, sabe? Geralmente, assim, tem equipes que elas ficam falando e às vezes fica deficitário em algum dos 2 pontos, mas não teve nem que perguntar muito, porque vocês já trouxeram vários precedentes e legislação no geral, achei isso muito bom. E o inglês de todas excelente, entendi absolutamente tudo, todas as frases, tudo. A questão da dicção também achei ótimo, não teve problema nenhum. Aí, agora, só para falar individualmente, a Júlia, eu fiz várias perguntas, foi meio sacana. Mas eu achei que você tem muito jogo de cintura para responder, assim, eu gostei que você respondia, você conseguia voltar ao ponto e ficou uma coisa lógica, assim, porque às vezes a pergunta não tem muito a ver, a pessoa volta, aí ela já desestruturou o discurso todo, assim, mas eu achei que você teve esse jogo de cintura para fazer isso. Você também mencionou, né, muita legislação, e você conseguiu parar mais ou menos quando deu tempo. Isso é muito importante, porque, assim, principalmente em rodada internacional, os juízes, tem juiz que fica meio indignado quando a pessoa continua a falar muito tempo. Eu acho difícil parar também, porque às vezes você está no meio do discurso, mas o seu time management foi muito bom, eu achei. No final, eu vou falar do rebuttal, que eu não acho justo falar agora. A Marcela, eu achei que você mencionou casos muito importantes, assim. Eu acho que você mencionou os casos certos para as perguntas que foram e para os assuntos que foram abordados, sabe? Eu gostei que você mencionou essa questão de sucessão de Estado, que é super importante, assim, né? Porque tem um time-lapse e tal. Acho que nem todas as pessoas lembrariam de mencionar isso, mas é super importante. Todas, né, achei super educadas, mas, assim, eu até escrevi, assim, muito educada. Não sei porque você teve um fluxo, assim, sabe, com licença, tipo assim, antes e depois das perguntas e tal, achei super, super, super educado, assim, os juízes, assim, fora, eles super prestam atenção nessa coisa, assim, de formato, de Your Excellency, por favor, PPP, o povo gosta disso. Você mencionou vários casos da ICJ sobre essa compensação, essa questão de compensação, os casos que você mencionou foram muito legais, assim, continue com eles, eu acho que tá perfeito. E aí a questão também, eu sei que você tinha muita coisa para falar quando deu tempo, mas assim, eu não sei se você olhou, porque também ficou olhando a janelinha e falando é super difícil, mas eu acho que você falou um pouquinho além, assim, quando deu tempo. Aí, tipo assim, só para meio que tentar fechar mais ou menos e aceitar que nunca dá para falar tudo, né? É meio frustrante, mas infelizmente é assim, né? Eu já sofri com isso também. E dos respondents, a Gabriela, eu achei que ela tem a dicção, assim, muito, muito boa. Você tem dicção para falar no Jornal Nacional, sabe? Eu fiquei, assim, horrorizada, como dá para entender cada sílaba de cada palavra, assim, achei até meio assustador, mas, assim, no bom sentido. E eu também achei muito bom essa questão, assim, que, sabe, eu acho que você até fez um curso de oratória já, porque você enfatizava as palavras certas, assim, na frase, sabe? Isso é muito importante quando você está apresentando alguma coisa, que nem o professor Bernardo falou, essa questão de formato, nossa, foi perfeita. E achei as respostas muito boas. Essa questão de legislação também, você mencionou, assim, eu acho que você conseguiu mencionar praticamente do seu tema todas as convenções e artigos que estavam citados no bench. Então, assim, né, falar o quê? Da parte da Caroline também, achei o formato dela excelente e eu gostei que você explorou muita coisa do direito humanitário internacional, vários conceitos, assim. Eu sei que esse é multa de direito ambiental, só que eu achei, assim, quando eu comecei a ler o caso, eu falei, meu Deus, isso aqui está parecendo uma multa de ambiental com humanitário, porque existe multa só de humanitário, mas essa estava juntando os dois e eu fiquei sofrendo pelas pessoas que teriam que apresentar, porque é muito conteúdo, assim. Essa parte de direito humanitário é muito grande também. Eu participei só de humanitário, é um absurdo de quantidade de material. E eu achei a conexão muito boa entre os argumentos também. Ficou uma estrutura assim, tudo estava conectado com o que você estava falando anteriormente, até quando teve pergunta, você conseguiu voltar. Isso é super importante, eu acho super difícil de fazer também. E a questão, quando você começou a falar do transboundary harm, dos casos da ICJ, caso perfeito. Sabe, é isso, assim. Eu acho que da parte do transboundary harm, você conseguiu falar com relativamente pouco tempo tudo que tinha que falar, questão de caso e questão de legislação, assim, achei ótimo. Aí, voltando para a Júlia do rebuttal, eu achei um dos melhores rebuttals que eu já vi, assim. Eu acho que você teve pouquíssimo tempo para falar e você conseguiu falar muita coisa em pouco tempo, sabe? Você conseguiu abordar, eu acho que quase todos os pontos que eu identifiquei como importantes, que eu fiquei falando assim, gente, quem for fazer rebuttal tem que falar isso, você acabou, você conseguiu falar, sei lá, em 4, 5 minutos, eu achei muito, muito bom. E o rebuttal é difícil porque você tá meio nervosa, que você tá querendo falar o máximo possível, né, então é frustrante, quando acaba o tempo você não consegue completar tudo, mas eu achei o seu rebuttal excelente, eu achei bem abrangente. Geralmente as pessoas, elas pegam, tipo assim, um tópico para falar, você conseguiu falar de uns 3 ou 4, loucamente, assim, você conseguiu falar tudo, achei muito, muito bom. E, sei lá, queria só dar parabéns e estou muito impressionada, assim, vocês estão na faculdade ainda, vocês estão nesse nível, sabe? Meu Deus. Daqui a alguns anos, assim, vocês vão estar voando demais. E espero que todas vocês continuem fazendo consigam trabalhar com direito ambiental, com certeza vão conseguir, fiquem na área, porque o direito ambiental está precisando muito de pessoas como vocês. E, assim, desculpem os homens que estão aqui assistindo, mas achei maravilhoso que são 4 mulheres excelentes, o direito ambiental precisa de muitas mulheres. E acho que a sensibilidade, assim, sabe, sei lá, eu sinto uma sensibilidade diferente. E, assim, espero muito que vocês consigam fazer uma bela carreira, tenho certeza, dentro do direito ambiental. Não mudem de área, gente, por favor. E é isso, nossa, parabéns demais. Eu acho que todos tinham que ir para a final, assim, nossa, eu estou torcendo para vocês irem para a final. Vocês estão muito de parabéns. Não sei em que período que vocês estão, mas só de estar na faculdade fazendo esse tipo de apresentação, sabe, eu achei muito impressionante. Enfim, vou parar de elogiar, mas eu achei tudo de bom.
Em nome do Instituto, considero encerrada a primeira rodada, né, da competição, das rodadas brasileiras, das rodadas nacionais da Stetson. Hoje foi só o primeiro dia. Se já foi nesse nível, imagine como é que vai ser o resto da competição. Então, fiquem todos ligados aí, que vai ser muito especial, sem dúvida nenhuma. Eu agradeço bastante a presença do professor Bernardo e da professora Monique. Foi, assim, uma rodada realmente muito boa. Parabenizo as equipes e vamos, que ainda temos mais bastante rodada aí para a gente aproveitar o conhecimento desses estudantes, mas que já são gente grande demais. Pessoal, a partir de agora eu vou encerrar a transmissão do YouTube, tá certo? E sintam-se à vontade para se despedirem, que daqui a pouco